Finlayson.
Mr. Speaker, as I stand to speak in the third reading speech, I reflect on how lucky we are as members of Parliament to be debating limitation law at 11:15 on a Wednesday night. There's nowhere else I'd rather be. And I have to say that, with respect, I thought the discussion in the committee was excellent. I particularly note the contribution of my friend Ms Pillay, and I say my friend advisedly because we enjoyed working together, she as chairperson and I as deputy chairperson of the Justice and Electoral Committee, even though we disagreed on everything, and she took the Labour members off on a wonderful jaunt to Australia, and I pulled the National members up because I thought that they should be at home working. But the one substantive point that was raised in the course of the discussion came from Mr Parker, who I thought made a substantive contribution to improving the bill with the amendments to clause 16, and I acknowledge the discussions we had. But he wanted to amend the Building Act long stop, and it could well be that there are very cogent arguments for so doing, and that there are benefits, as he said, in uniform limitation periods. But I think this is an issue that needs to be canvassed in the context of the current Building Act review, and his proposed amendment, which was a very serious amendment with very serious consequences, would really need to be consulted on, and that was the proposal I put in the committee stages. It wasn't accepted, but I do think that that's the best way to move forward. So, Mr Speaker, I am very pleased to move that the limitation bill be now read a third time. It replaces a 60-year-old piece of legislation. It's very important because, as Ms Pillay says, it addresses the problems that have been identified with the current Act's substance and drafting. It clarifies and improves general limitation rules, although there are specific limitation rules in other statutes. And these rules determine how long people have to bring a civil claim before defendants can argue that the claim is time-barred. The justice system gives people access to the courts to settle disputes they cannot otherwise settle themselves. But these kinds of rules are needed as, and I think Mr Parker alluded to this on a number of occasions in the committee stages, it's unjust for people to have to defend claims about something that may have occurred many years earlier merely because the claimant has delayed bringing the case. So these rules are designed to strike a fair balance between the conflicting interests of claimants and defendants, and without these rules, people could be or face potential liability for an indefinite period for which they'd need to maintain records and professional insurance and so on. And importantly, the rules address the important public interest in the timely resolution of claims. So the path to the 1950 Act's reform has not been entirely straightforward. I acknowledge the work of the Law Commission over many years. They started with a preliminary discussion paper in 1987, and then there were further discussion papers and reports in 1998, 2000 and 2007. And it's a tribute to the Law Commission, and Sir Geoffrey Palmer took a very special interest in this reform that we are where we are now. There was an exposure bill published in 2008. Submissions were received on the bill. The Commission then convened a working group of interested persons to consider these changes, and the then Minister of Justice gave permission for me to be on that working group. I thought that was very sporting of Annette. And this further work resulted in some significant restructuring and refinement of the bill before its introduction in 2009. So I conclude by thanking the Law Commission for their work, for the Justice and Electoral Committee for their good work, and think that what we have now is a very sensible piece of legislation that will stand the test of time, although I hope it's not another 60 years before this Parliament takes another look at this very important area of law. So Mr. Speaker, the primary 6-year limitation period is carried forward. We have this new 3-year late knowledge period introduced to address the problem identified by the courts and other experts that people sometimes only discover they have a claim after a limitation period has ended. And then we have the 15-year long stop that has been the subject of quite a lot of debate tonight. The new period's not going to apply if there's fraud or if a claimant is incapacitated, and as has been canvassed tonight in some rare cases where minors, for example, have been abused or where the evidence of a personal injury develops over many years, the court is going to be able to exercise a discretion to grant monetary relief. So I think all speakers have noted that limitation law can be complex, but it is truly fascinating, and especially I say to Mr Robertson, if he really wants a riveting read, go to the transitional provisions of this bill. They are very, very interesting, and I know that he will enjoy that more than anything he's done in recent times. So I echo the words of Lynn Pillay. This bill is a major achievement in ensuring that the rules are fairer and easier to understand and apply. I thank everyone who's played a part in the debate, and I commend the bill to the House.
The question